This is LXBN TV, and I'm Colin O'Keefe. Just yesterday, an individual affiliated with social hacktivist group Anonymous took down a sizable chunk of the web by attacking GoDaddy and its servers. To discuss, we bring in Travis Crabtree, attorney with Looper Reed and McGraw and author of the eMedia Law Insider. Travis, what are the legal implications of a distributed denial of service attack as is suspected here, where a hacker may not necessarily break in anywhere, but hits a target with so many requests that it is rendered useless?
Sure. The obvious law is what's called the Computer Fraud and Abuse Act. And yes, that is geared toward more traditional hacking where you actually gain access to a computer and take some data or do something once you gain access and go on it. Now, the distributed attack or the direct attack is a little different where you're just overloading the system so that real customers and real people requesting the page can't get to it. So they're not really accessing anything that you or I couldn't access on a daily basis from a site like GoDaddy. But nevertheless, the CFAA, the Computer Fraud and Abuse Act, would still apply because it makes it illegal to transmit commands, that's the word in the statute, to others through computers that causes damage to any protected computer. And a protected computer under the Act is any computer engaged in interstate commerce. And when you're on the internet, you're engaged in interstate commerce because you're connected not only between states but globally.
Definitely. And of course, this group, Anonymous, believes themselves to be activists. So could anyone who is prosecuted for something like this claim that they are engaging in speech as a defense against whatever charges they may face?
They sure can, and no doubt that they will. There have been a couple of prosecutions, or at least prosecution attempts, from some of these guys who have been unmasked through some discovery and through some technical ways to get some digital forensics on some of these folks. And in fact, there's a case out of California, Santa Clara County. A homeless hacktivist went into there and did one of these attacks on the county servers because there was a homeless camping ordinance he was protesting. He was arrested. It took about 9 months before the FBI figured out he was responsible, or at least partially responsible, and charged under the CFAA. His lawyer did exactly what you're talking about, said, this is not terrorism, this is not hacking, this is nothing but free speech. And they said that's the same thing as sitting in at a bank. If you send a bunch of protesters into a bank or a lunch counter back in the 60s, it's the same concept. You're just preventing that business from engaging in its real business with its customers, and it's no different from those. And so he's raised the defense. Unfortunately, the individual that was indicted has run off to Canada, and last reports that I've seen from about May of this year on that story. So I'm not sure we're going to get a definitive answer or any case law anytime in the near future, but it's certainly a defense that anybody would raise.
Interesting, interesting. This will be one to watch going forward. Hopefully we don't see more attacks like this, but you get the sense that you might going forward. So we'll have to see what happens. Well, once again, that was Travis Crabtree of Looper Reed and McGraw and the eMedia Law Insider. For more of his insight, be sure to visit emedialaw.com. And for curated commentary from the LexBlog Network's thousands of authors, be sure to visit us at lxbn.lexblog.com. Thanks, Travis.
Thank you.